The world of law enforcement is a complex one, filled with challenges and responsibilities that require a delicate balance. It's a delicate dance between maintaining order and upholding individual rights, a task that demands both vigilance and empathy. At the heart of reasonable suspicion lies a concept as crucial as it is controversial: reasonable suspicion. This principle is not just a legal term, but a cornerstone of effective policing. This legal principle is the lifeblood of effective policing, the linchpin that allows officers to investigate potential criminal activity without infringing upon the freedoms guaranteed by the Constitution. It is the fine line that officers walk every day. Reasonable suspicion is the linchpin that allows officers to investigate potential criminal activity without infringing upon the freedoms guaranteed by the Constitution. It is a safeguard, ensuring that the power vested in law enforcement is exercised judiciously. Reasonable suspicion in its simplest form is more than a mere hunch or a gut feeling. It is a standard that requires a justifiable belief based on specific and articulable facts. It's a level of certainty, a justifiable belief based on articulable facts that a crime may be afoot. This belief must be grounded in observable behavior and circumstances. This standard, though lower than probable cause, empowers law enforcement to act, to probe, to ask the tough questions that might prevent a crime from occurring. It allows officers to delve deeper into situations that might otherwise go unnoticed, all while respecting the delicate balance between security and liberty. This balance is crucial in maintaining public trust and ensuring that the community feels both safe and respected. Imagine a lone officer patrolling a quiet suburban street, the humdrum of normalcy suddenly broken by a shadowy figure lurking near parked cars. His training, his experience, and his instincts all come into play. His training, his experience, the subtle cues of human behavior all whisper a silent alarm. This is where reasonable suspicion begins. This isn't about profiling based on race or appearance. It's about recognizing patterns, deviations from the norm that raise red flags in the mind of a trained professional. It's about understanding human behavior and the context in which it occurs. Consider a scenario where an officer notices a person repeatedly circling a block, peering into car windows. This behavior, coupled with the time of night and the area's history of car thefts, forms a reasonable suspicion. Or imagine an officer observing a known drug dealer engaging in a series of quick hand-to-hand exchanges in a high-crime area. These specific and articulable facts provide a basis for reasonable suspicion. It's the first crucial step in a long chain of events that may ultimately lead to the apprehension of a criminal and the protection of the innocent. This process, though fraught with challenges, is essential for maintaining public safety. In the end, reasonable suspicion is not just a legal standard. It is a vital tool that helps law enforcement officers serve and protect their communities effectively and justly. In the shadowy world of criminal investigation, nothing is black and white. The line between right and wrong, between innocent and guilty, is often blurred, shrouded in shades of gray. There are no crystal balls, no guaranteed formulas. The process is far from straightforward, and certainty is a luxury rarely afforded to those in the field. Instead, officers rely on a combination of experience, training, and an almost instinctive ability to read the subtle cues of human behavior. This skill is honed over years of practice, observation, and learning from both successes and mistakes. This is the art of building reasonable suspicion, of piecing together a mosaic of indicators that, when viewed as a whole, paint a compelling picture of potential criminal activity. Each clue, no matter how small, is a vital piece of the puzzle. Consider the seemingly innocuous, a car parked haphazardly on a deserted street late at night. To the untrained eye, it might appear as nothing more than a minor traffic violation, an individual nervously avoiding eye contact, their hands trembling as they reach into their pocket. This behavior, while not inherently criminal, raises questions and warrants further observation. An out-of-place vehicle, its license plate obscured, parked near a business after hours. Such details, though seemingly trivial, can be significant in the broader context of an investigation. These, in isolation, might be dismissed as mere coincidence, the product of absent-mindedness or innocent circumstance. However, when combined with other factors, they can form a pattern that is hard to ignore. But to the trained eye, they are puzzle pieces, each one adding to a growing sense of unease, of suspicion that something is amiss. The ability to discern these patterns is what sets experienced officers apart. Perhaps there's a history of break-ins in the area, a pattern of similar vehicles being used in past crimes. This historical context provides a backdrop against which current observations can be measured. Maybe the individual's attire, their demeanor, their very presence sets off alarm bells, triggering memories of past encounters, of known criminal profiles. These mental associations are crucial in forming a reasonable suspicion. It's important to note that these indicators are not about judging a book by its cover. Officers are trained to look beyond superficial characteristics and focus on behavior and context. They're not about targeting individuals based on race, religion, or any other protected characteristic. The goal is to ensure that all actions are based on objective observations and evidence. They are, however, about recognizing patterns, about understanding that crime, by its very nature, often follows predictable paths, and that criminals, despite their best efforts, often leave telltale signs in their wake. This understanding is built on a foundation of knowledge and experience. This is the essence of building reasonable suspicion, the ability to connect the dots, to see the forest for the trees, to recognize that sometimes the most innocuous details can be the most telling. It's a skill that requires both intuition and analytical thinking. It's about trusting your gut but verifying it with concrete, articulable facts, ensuring that every action taken is justified, legal, and above all, protects the rights of all citizens. This balance between instinct and evidence is what defines effective law enforcement. The roots of reasonable suspicion are deeply intertwined with the very fabric of American jurisprudence, a testament to the ongoing struggle to balance individual liberties with the need for public safety. This balance is not just a legal necessity, but a reflection of the values that underpin American society. While the Fourth Amendment to the Constitution guarantees protection against unreasonable searches and seizures, it's the interpretation, the evolution of legal precedent, that has given rise to the concept of reasonable suspicion as we know it today. This evolution has been shaped by numerous court cases, legal debates, and societal changes over the years. For much of American history, the standard for law enforcement to detain and question an individual was probable cause, a higher threshold requiring concrete evidence that a crime had been, was being, or was about to be committed. This standard was designed to protect citizens from arbitrary and unjustified intrusions by the state. This standard, while safeguarding against arbitrary intrusions, often proved cumbersome, hindering officers from proactively addressing suspicious activity before it escalated into criminal acts. Law enforcement officers found themselves in a difficult position, needing to act swiftly to prevent crime, but constrained by the need for concrete evidence. The landmark case of Terry vs. Ohio in 1968 marked a pivotal shift in this legal landscape. This case arose from an incident where a police officer observed suspicious behavior and conducted a search without probable cause, leading to a significant legal challenge. The Supreme Court, recognizing the unique challenges faced by law enforcement in preventing crime on the streets, carved out a middle ground, the standard of reasonable suspicion. This new standard allowed officers to act on less concrete evidence, provided they could articulate specific reasons for their suspicion. This landmark ruling acknowledged that officers, when presented with specific, articulable facts suggesting criminal activity, could conduct brief investigatory stops, commonly known as Terry stops, to ascertain the situation. These stops were intended to be limited in scope and duration, designed to allow officers to quickly determine whether further action was necessary. This decision was not without controversy. It sparked a heated debate about the balance between public safety and individual rights. Critics argued that it eroded Fourth Amendment protections, giving officers too much leeway to detain individuals based on subjective interpretations of behavior. They feared that this could lead to abuses of power and violations of civil liberties. Proponents, however, hailed it as a vital tool, allowing officers to proactively address suspicious activity to prevent crime from occurring, all while respecting the constitutional rights of those they swore to protect. They argued that reasonable suspicion provided a necessary flexibility for law enforcement to effectively do their jobs. This delicate balance, this constant tug-of-war between security and freedom, lies at the heart of reasonable suspicion. It is a principle that requires careful application and constant vigilance to ensure that it serves its intended purpose without overstepping constitutional boundaries. It's a legal principle born from necessity, a recognition that in the fight against crime, law enforcement needs the flexibility to act, to investigate, but always within the boundaries of the Constitution. As society continues to evolve, so too will the interpretation and application of reasonable suspicion, reflecting the ongoing dialogue between the need for security and the preservation of individual freedoms.